All right, my friends, welcome back to Antiwar Radio, Chaos 92.7 FM in Austin, Texas. And now joining me on the line is the great blogger Glenn Greenwald. You can read what he writes at salon.com/opinion/Greenwald. And he's the author of the books How Would a Patriot Act, A Tragic Legacy, and the new one is Great American Hypocrites. Welcome back to the show, Glenn.
Great to be back, Scott. Thanks.
Yeah, it's good to have you here, and I got to congratulate you on just the incredible work that you've been doing on the blog lately here, going after these Democrats in the Congress for selling us out on immunity for the telecoms. Well, and beyond that, let's get to the specifics of the bill. Beyond the immunity for the telecoms, which I think we can address in a minute, specifically, what does this bill do in terms of revising the FISA statute? Or does it replace it?
That it does is that one of the key limitations on the government's ability to eavesdrop under the old FISA, meaning the FISA that has been in place since 1978, is that the government could not tap into the telephone network or other communication devices inside of the United States without going in and getting a FISA warrant. So it couldn't tap into the AT&T room or into servers, computer servers that carry our emails or things like that. What this bill does is it completely eliminates that restriction. So the government is now able not only to tap into telecommunication equipment inside the United States in order to look for specific individuals' communications, it's actually able to tap into the physical infrastructure, the fiber optic cables and servers and the like, doing a vacuum cleaner search, looking for any sort of communication at all, provided that the person who's being targeted is reasonably believed to be outside the United States and that the purpose of the surveillance is foreign intelligence. So the sum and substance is that there's no judicial oversight for that process. It's the executive branch on its own that makes those decisions. They don't have to prove or even allege that the person that they're surveilling outside the United States that they're targeting has any connection to terrorism at all. There's actually no requirement at all other than that it be for the purposes of foreign intelligence, which is very broad. And so it really enables this massive expansion of warrantless eavesdropping for the international telephone calls and email exchanges of Americans inside the United States when communicating internationally.
Mm-hmm. Now, you linked actually in your entry today to this analysis at Balkanization, Jack Balkan's blog, and he talks about that reasonably believed to be outside the U.S., and that sounds familiar to me. That's officially a notch or two notches below probable cause, right?
Right. I mean, you're already talking about eliminating an important part of the probable cause standard, which is that you don't need to even think that the person has done anything wrong. You don't need to think that they're an agent of a foreign government or a foreign power or a terrorist organization. All you need to think about that person is that they're outside of the United States. And you don't even need probable cause that they're outside the United States. Like you said, all you need is reasonable suspicion that they're outside of the United States or reasonable grounds to believe they're outside the United States. And then you can target them and tap into the American phone network or email server network and monitor all of their communications.
Mm-hmm. Yeah, and, Balkan says in there, whoever was writing there at Balkanization wrote that, the focus on the removal from the courts, the ability to review these things, is actually no big deal because the statute is written so broadly that any court reviewing any of this would have to just give it a rubber stamp anyway.
Well, that's right. I mean, the key under FISA is that in order to be able to target someone, you needed to have probable cause to believe that they were an agent of a foreign power, that they were actually working for or working in connection with a foreign government or a terrorist organization. That requirement has been completely eliminated. So all you need to think about them is that they're outside the United States and then prove that you're doing it for purposes of foreign intelligence. But because that is such a broad standard, I mean, anything that you say you're doing in order to protect the country, you can say is for purposes of foreign intelligence, as you just suggested, then it would be easy to go to a court under any circumstance, anyone you wanted to target, and say that it fits within the parameters of the statute. So it's almost true that whether there's judicial review is secondary to just how broad these standards are for when it's now permissible to eavesdrop.
Mm-hmm. And now you point.
But let me just add to that, which is, the FISA court, of course, it was extremely easy to get warrants into the FISA court. They were successful in almost every single instance, all 28,000 times when they asked. In every case except a small handful, 3 or 4, they were told that they could, that their warrant was approved. So it was very easy under the FISA court too. There's still a benefit to judicial review, though, even when it's a rubber stamp, which is that you're forcing the executive in advance to tell another body outside of the purview of the executive branch on whom they intend to spy. And the theory, anyway, is that will reduce the capacity for abuse when you have to disclose ahead of time who you're targeting. And that form of check and limitation is abolished by this bill.
All right, now, and then there's the immunity for the telecoms, and this says that the telecoms who conspired with the Bush administration to break the law have retroactive immunity, which I guess the real meat of this means that somebody like James Bamford or somebody who would have, a very credible reason to believe that they would be one of the people spied on have no standing to sue anymore, which means no discovery, which means no accountability for what they've done in the past.
Right. Nobody has standing to sue. The telecoms get full and absolute immunity under this bill for the spying that they enable. And keep in mind that what's so important here is that it isn't just that the government is prohibited from spying on Americans without warrants under FISA. There are specific statutes that have been enacted by the Congress specifically to prohibit telecommunications companies from sharing customer data and enabling access to the communications of customers with the government without warrants as well. I mean, those are specifically directed to the telecoms, and those are the laws that the telecoms broke for years by allowing access to their customers' communications without warrants required by law. So it's the telecoms themselves that directly broke these laws. They're being sued by their customers, people who have an expectation that they will comply with those laws when you sign up for them and you talk on over the wires controlled by Verizon or Sprint or AT&T. And what this bill does is say that as long as the Attorney General goes into court and certifies to a few different facts that we already know in advance he's going to certify to, the court doesn't examine whether those claims are true. The court doesn't ask for evidence proving that they're true. The mere fact that the Attorney General makes these statements in court in secret compels the court to dismiss all of the lawsuits against the telecoms permanently. And as you say, that means we'll never find out what the telecoms did. We'll never find out what the Bush administration did. And we won't get a judicial ruling as to whether any of this was illegal.
So even the judge is not allowed to see the evidence.
Right. The judge is allowed to see a little bit of evidence. For example, the Attorney General has to say in a statement, the President gave written requests to the telecoms in order to do the spying, and the President told the telecoms that doing this was legal. So the judge is allowed, we're not allowed to see it, but the judge is allowed to see the underlying written directives from the President to the telecoms that said these things. But the judge isn't allowed to know whether the spying was really done to stop terrorism or to spy on political opponents. The judge isn't allowed to know the extent of the spying, on whom the spying took place, the way in which they were selected, what was done with the information. The judge is required blindly to rely on the certification of the Attorney General and the President's statement that they did this in order to deter terrorist attacks.
Mm-hmm. And now, something else, I forget if this was brought up on your blog or over at Balkanization, was the turning over of intelligence information to domestic police agencies as a way for the FBI to, for example, it seems like, get around the Fourth Amendment and still be able to prosecute you.
Well, I mean, just in general, there had been a separation between foreign intelligence gathering and turning over information to the FBI for exactly that reason, that because information gathered by the NSA was so much more easily obtained than what the FBI was allowed to do, because the former was for foreign intelligence and the FBI is for law enforcement, there had been this separation between what the NSA could find and what they could tell the FBI. That separation has been almost eroded completely in the aftermath of 9/11, so that now the NSA is more or less free to pass on to the CIA or to the FBI or domestic intelligence law enforcement agencies information that they obtain. So the more information that you allow the NSA to obtain without warrants, the more the FBI will learn of it, and just standard federal prosecutors will learn about it, and the more that evidence can be used in the prosecution of just standard crimes. And so it goes far beyond just an invasion of privacy of Americans to have privacy in our communications, it also goes to the core of the Fourth Amendment, which is prohibiting the government from gathering information without probable cause to then use against citizens for prosecution.
You know, a big part of this, too, is establishing the precedent, really, that the president can do whatever he wants, and the Congress, no matter who's the president or who's the Congress, they'll simply rubber stamp this because, as I know you've explained repeatedly, FISA already breaks the Fourth Amendment to little bitty pieces. I mean, they can tap phones for 3 days and then tell the judge, hey, by the way. And even, as you pointed out in your speech at the Future Freedom Foundation, the FISA court is hardly a court at all. It's a Article II court inside the Justice Department building. It's like a grand jury setup where there's no defense lawyers present, anything like that. So if there were any real revisions that needed to be made for technology, such as a guy in Pakistan calls Afghanistan, but the call is somehow routed through the United States or something like that, we're talking about cosmetic adjustments that anyone could even argue needed to be made to FISA. It was already so broad.